Oh, it's all right. We'll get you one. That's good.
Everyone may be seated. I apologize. I was trying to make sure I got this situated correctly on our YouTube Zoom feed. So I'm not sure that I do, but it's best I can do for the time being. Folks, here's what we're going to do next. I'm going to do very similarly to what I did with the preliminary instructions. I'm going to read the final instructions to you. And they include some of the ones from the preliminary instructions, and of course, some significantly different ones or additional ones. So follow along if you like, or listen if you like, but you have your own set. And then when we're done with that, we will proceed with the closing arguments by counsel, and then finalize this matter when that's all completed. So I'm going to begin on page 1. It's not numbered page 1, but you'll know it's the big top of the page. So the trial information charges the defendant, Nathaniel John Parker III, with the crime of murder in the first degree. Murder in the first degree also includes the lesser offenses of murder in the second degree, attempt to commit murder, voluntary manslaughter, willful injury causing serious injury, assault causing serious injury, involuntary manslaughter while committing a public offense, willful injury causing bodily injury and involuntary manslaughter, assault with the intent to inflict serious injury, and assault causing bodily injury and assault. Number 2, the trial information is the document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for trial. It is not evidence. Number 3, the defendant has entered a plea of not guilty. The plea of not guilty is a complete denial of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you, the state must prove something. It must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Number 4, you must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. My duty is to tell you what the law is. Your duty is to accept and apply this law and to decide all fact questions. You must consider all the instructions together. No one instruction includes all of the applicable law. As you consider the evidence, do not be influenced by any personal sympathy, bias, prejudices, or emotions. It is common to have hidden or implicit thoughts that help us form our opinions. You are making very important decisions in this case, so you must evaluate the evidence carefully. You must avoid decisions based on things such as generalizations, gut feelings, prejudices, fears, sympathies, stereotypes, or inward or outward biases. The law demands that you return a just verdict based solely on this evidence, your reason and common sense, and these instructions. As jurors, your sole duty is to find the truth and do justice. Number 5, the defendant is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes a guilt beyond a reasonable doubt. Number 6, the burden is on the state to prove the defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case or from the lack or failure of evidence produced by the state. If after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if after a full and fair consideration of all the evidence in the case, or lack of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt and you should find the defendant not guilty. Number 7. If there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Number 8. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Number 9. Nothing I've said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Number 10, you should base your verdict only upon the evidence and these instructions. Evidence is testimony in person or by deposition, exhibits received by the court. You may examine these exhibits closely, but be careful not to alter or destroy them. 3, stipulations, which are agreements between the parties, or the attorneys and then the parties. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers. 2, objections and rulings on objections. 3, any testimony I told you to disregard. 4, anything you saw or heard about this case outside the courtroom. 11, in determining or considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Number 12, decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead on the nature and quality of the evidence that's presented. There are many factors you may consider in deciding what testimony to believe. For example, 1, whether the testimony is reasonable and consistent with other evidence that you believe. 2, whether a witness has made inconsistent statements. 3, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts. 4, the witness's interest in the trial, their motive, candor, bias, and prejudice. Number 13, you've heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinion. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves. Considering the witness's education and experience, the reasons given for the opinion, and all the other evidence in the case. Number 14. You've heard evidence claiming the witness or witnesses made statements before this trial while under oath, which were inconsistent with what they said in this trial. If you find these statements were made and were inconsistent, then you may consider them as part of the evidence, just as if it had been made at this trial. You may also use these statements to help you decide if you believe the witness or witnesses. You may disregard all or any part of the testimony if you find the statements were made and were inconsistent with the testimony given at trial, but you're not required to do so. Do not disregard the trial testimony if other evidence you believe supports it or you believe it for any other reason. 15. Evidence has been offered to show that the defendant made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence. You may also use these statements to help you decide if you believe the defendant. You may disregard all or any part of the defendant's testimony if you find the statements were made and were inconsistent with the defendant's testimony given at trial. But you're not required to do so. Do not disregard the defendant's testimony if other evidence you believe supports it or you believe it for any other reason. 16, to commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Number 17, where two or more alternatives where two or more alternative theories are presented, or where two or more facts would produce the same result, the law does not require each juror to agree as to which theory or fact leads to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. Excuse me. Number 18. The state must prove all the following elements of murder in the first degree. 1, on or about the 24th day of February, 2023, the defendant stabbed William Harlan. 2, William Harlan died as a result of being stabbed. 3, the defendant acted with malice aforethought. 4, the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill William Harlan. If the state has proved all the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree, explained in instruction number 27. Number 19, malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another or in disregard of the rights of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Number 20, willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. 21, deliberation and premeditation need not exist for any particular length of time before the act. Number 22, concerning element number 2 of instruction number 18, the stab wound inflicted by the defendant resulted in death of William Harlan if it caused or directly contributed to William Harlan's death. Number 23, specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Number 24, if a person has the opportunity to deliberate and uses a dangerous weapon against another, resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and specific intent to kill. Number 25. Malice aforethought may be inferred from the defendant's use of a dangerous weapon. Number 26, a dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner, is capable of inflicting death. It is also any sort of instrument or device actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. You are instructed that a knife having a blade exceeding 5 inches in length by law is a dangerous weapon. Number 27, the state must prove all the following elements of murder in the second degree. 1, on or about the 24th day of February 2023, the defendant stabbed William Harlan. 2, William Harlan died as a result of being stabbed. 3, the defendant acted with malice aforethought. If the state has proved all the elements, the defendant is guilty of murder in the second degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of attempted to commit murder as explained in instruction number 29. Number 28, murder in the second degree does not require a specific intent to kill another person. 29, the state must prove all the following elements of attempt to commit murder. 1, on or about the 24th day of February 2023, the defendant stabbed William Harlan multiple times. 2, by his acts, the defendant expected to set in motion a force or chain of events which would cause or result in the death of William Harlan. 3, when the defendant acted, he specifically intended to cause the death of William Harlan. If the state has proved all the elements, the defendant is guilty of attempted to commit murder. If the state has failed to prove any one of the elements, the defendant is not guilty of attempt to commit murder, and you will then consider the charge of voluntary manslaughter as explained in instruction number 30. Number 30, the state must prove all the following elements of voluntary manslaughter. 1, on or about the 24th day of February 2023, the defendant intentionally stabbed William Harlan. 2, William Harlan died as a result of being stabbed. 3, the stabbing was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all the elements, the defendant is guilty of voluntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of voluntary manslaughter, and you will then consider the charge of willful injury causing serious injury as explained in instruction number. And gentlemen, my copy does not have we failed to mark that blank. I think that is instruction number 32. So there you go. Put number 32 in yours, if you would, please. Thank you. Instruction number 31, concerning element number 3 of instruction number 30, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Words alone, however, abusive and assaulting, cannot be serious provocation. Number 32, the state must prove all of the following elements of willful injury causing serious injury. 1, on or about the 24th day of February 2023, the defendant stabbed William Harlan multiple times. 2, the defendant specifically intended to cause serious injury to William Harlan. 3, the defendant's acts caused a serious injury to William Harlan as defined in instruction number 33. If you find the statement, the state has proved all the elements, the defendant is guilty of willful injury causing serious injury. If the state has failed to prove any one of the elements, the defendant is not guilty of willful injury causing serious injury, and you will then consider the charge of assault causing a serious injury as explained in instruction number 34. Instruction number 33, an element of the crime charged is that the victim suffered a serious injury. A serious injury is a bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or extended loss or impairment of the function of any bodily part or organ. Number 34, State must prove all the following elements of assault causing a serious injury. One, on or about the 24th day of February 2023, the defendant did an act which was A, specifically intended to cause pain or injury to William Harlan. B, specifically intended to result in physical contact, which was insulting or offensive to William Harlan. Or C, specifically intended to place William Harlan in fear of an immediate physical contact, which would have been painful, injurious, insulting, or offensive to him. It is not necessary for all jurors to agree to just A, B, or C. It is only necessary that all jurors agree to at least one of the three alternatives. Element number 2, the defendant had the apparent ability to do the act as defined in instruction number 35. Number 3, the defendant's act caused a serious injury to William Harlan as defined in instruction number 33. If the state's proved all the elements, the defendant is guilty of assault causing serious injury. If the state has failed to prove any one of the elements, the defendant is not guilty of assault causing a serious injury, and you will then consider the charge of involuntary manslaughter while committing a public offense, as explained in instruction number 36. Number 35, concerning element number 2 of instruction number 34, apparent ability means a reasonable person in the defendant's position would expect the act to be completed under the existing facts and circumstances. Number 36, the state must prove both the following elements of involuntary manslaughter while committing a public offense. 1, on or about the 24th day of February 2023, the defendant recklessly committed the crime of assault. A person commits an assault when a person does an act which is specifically intended to cause pain or injury and or result in physical contact which will be insulting or offensive and or place another person in fear of immediate physical contact which will be painful, injurious, insulting, or offensive to another person. When coupled with the apparent ability to do the act, or a person intentionally points a firearm towards another, or intentionally displays a dangerous weapon in a threatening manner toward another. Recklessly is defined in instruction number 37. 2, when the defendant committed the crime of assault, the defendant unintentionally caused the death of William Harlan. If the state has proved both the elements, the defendant is guilty of involuntary manslaughter while committing a public offense. If the state has failed to prove either of the following, the defendant is not guilty of involuntary manslaughter while committing a public offense, and you will then consider the charge of willful injury causing a bodily injury as explained in instruction number 38. Number 37, a person is reckless or acts recklessly when he willfully disregards the safety or of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be so obvious that the actor knows or should reasonably foresee that harm will more than likely not result from the act. Though recklessness is willful, it is not intentional in the sense that harm is intended to result. Number 38, the state must prove all the following elements of willful injury causing bodily injury. 1, on or about the 24th day of February 2023, the defendant stabbed William Harlan multiple times. The defendant specifically intended to cause a serious injury to William Harlan. That's number 2. Number 3, the defendant's acts caused a bodily injury to William Harlan as defined in instruction number 39. If you find the state has proved all the elements, the defendant is guilty of willful injury causing bodily injury. If the state has failed to prove any one of the elements, the defendant is not guilty of willful injury causing bodily injury, and then you will consider the charge of involuntary manslaughter as explained in instruction number 40. Number 39, the term bodily injury means physical pain, illness, or any impairment of physical condition. Number 40, the state must prove all the following elements of involuntary manslaughter. 1, on or about the 24th day of February 2023, the defendant recklessly stabbed William Harlan. 2, the defendant did the act in a manner likely to cause death and or serious injury. By doing the act, number three, I should say, by doing the act, the defendant unintentionally caused the death of William Harlan. If the state has proved all the elements, the defendant is guilty of involuntary manslaughter. If the state has failed to prove any one of the elements, the defendant is not guilty of involuntary manslaughter. And then you should consider the charge of assault with the intent to inflict serious injury as explained in instruction number 41. Number 41, the state must prove all the following elements of assault with the intent to inflict serious injury. 1, on or about the 24th day of February, 2023, the defendant did an act which was A, specifically intended to cause pain or injury to William Harlan, B, specifically intended to result in physical contact, which was insulting or offensive to William Harlan, or C, specifically intended to place William Harlan in fear of an immediate physical contact, which would have been painful, injurious, insulting, or offensive to him. It is not necessary for all jurors to agree to just A, B, or C. It's only necessary that all jurors agree to at least one of these three alternatives. And number 2, the defendant had the apparent ability to do the act as defined in instruction number 35. 3, the act was done with the specific intent to cause a serious injury as defined in instruction number 33. If the state has proved all the elements, the defendant is guilty of assault with intent to inflict serious injury. If the state has failed to prove any one of the elements, the defendant is not guilty of assault with the intent to inflict serious injury. And then you will consider the charge of assault causing bodily injury as explained in instruction number 42. Number 42, the state must prove all the following elements of assault causing bodily injury. 1, on or about the 24th day of February, 2023, the defendant did an act which was A, specifically intended to cause pain or injury to William Harlan. B, specifically intended to result in physical contact which was insulting or offensive to William Harlan. Or C, specifically intended to place William Harlan in fear of an immediate physical contact which would have been painful, injurious, insulting, or offensive to him. It's not necessary for all jurors to agree to just A, B, or C. It's only necessary that all jurors agree to at least one of the three alternatives. 2, the defendant had the apparent ability to do the act as defined in instruction number 35. 3, the act caused a bodily injury to William Harlan as defined in instruction number 39. If the state has proved all the elements, the defendant is guilty of assault causing bodily injury. If the state has failed to prove any one of the elements, the defendant is not guilty of assault causing a bodily injury, and you will then consider the charge of assault as explained in instruction number 43. Number 43, the state must prove all the following elements of assault. 1, on or about the 24th day of February, 2023, the defendant did an act which was A, specifically intended to cause pain or injury to William Harlan. B, specifically intended to result in physical contact which was insulting or offensive to William Harlan. Or C, specifically intended to place William Harlan in fear of an immediate physical contact which would have been painful, injurious, insulting, or offensive to him. It's not necessary for all jurors to agree to just A, B, or C. It's only necessary that all jurors agree to at least one of the three alternatives. 2, the defendant had the apparent ability to do the act as defined in instruction number 35. If the state has proved all the elements, the defendant is guilty of assault. If the state has failed to prove any one of the elements, the defendant is not guilty. 44, you may not communicate about this case before reaching your verdict. This includes via cell phone and electronic media such as text messages, emails, electronic messaging applications, and any social media platforms, including but not limited to Facebook, LinkedIn, YouTube, Twitter, TikTok, Instagram, Snapchat, and any other social media applications you may use. Do not do any research or make any investigation about this case on your own. Do not visit or view any place discussed in this case. Do not use the internet or application-based maps or programs or any other application program or device to search for and view any place discussed in the testimony. Also, do not research any information about the case, the law, or the people involved, including the parties, the witnesses, the lawyers, or the judge. This includes using the internet to research events or people referenced in the trial. This case was tried on evidence presented in this courtroom. If you conduct independent research, you will be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do some research or investigation or an experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth and by cross-examination. All the parties are entitled to a fair trial rendered by an impartial jury, and you must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based upon information not presented in court, you will have denied the parties a fair trial in accordance with the rules of this state, and you will have done an injustice. And it's very important that you abide by these rules. Failure to follow these rules may result in the case having to be retried and could result in you being held in contempt and punished. I don't mean to be too heavy-handed there, but it's that important. Number 45. During the trial, you've been allowed to take notes. You may take these notes with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. 46, when you begin your deliberations, you should select a foreman or forewoman. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after the impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. But do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors, or for the mere purpose of returning a verdict. Remember, you are the judges of the facts. Your sole duty is to find the truth and do justice. And then finally, 47, I'm giving you a verdict form and it's attached. When you've agreed upon your verdict and the foreman or forewoman has signed the verdict form, please notify the court attendant. It's signed and dated today's date. And then the verdict form is the last page. It says, we, the jury, find the defendant on count 1 of the trial information. You must check only one box. And there's a place for you to select or make your selection. It starts with guilty of murder in the first degree, guilty of murder in the second degree, guilty of attempted to commit murder, guilty of voluntary manslaughter, guilty of willful injury causing serious injury, guilty of assault causing serious injury, guilty of involuntary manslaughter while committing a public offense, guilty of willful injury causing bodily injury, guilty of involuntary manslaughter, guilty of assault with the intent to inflict serious injury, guilty of assault causing a bodily injury, guilty of assault, and the last entry is not guilty, and a place for the jury foreperson to sign when the jury is unanimous. Mr. Loomis, are you ready to present the state's closing?
Yes, Your Honor.
You may when you're ready.
You may please the court.
Mr. Loomis?
Mr. Lowe's. Wolford. Good morning, ladies and gentlemen of the jury. First, let me thank you for your time and your attention throughout the last week and your patience as we worked our way through the evidence. And over a period of 3 days, we've heard a lot of evidence, both direct evidence and circumstantial evidence. Direct evidence from witnesses on scene and circumstantial evidence or a chain of facts that lead you to a conclusion. A conclusion that William Harlan was murdered on February 24th of 2023. That night. And both the direct and circumstantial evidence tell you a lot of things. Show you a And one of the things that I think is most important that all that evidence shows is that when William Harlan went to the Select Mart that night, he left the Select Mart not sad. There is no evidence, ladies and gentlemen of the jury, that when William Harlan gets into that car at 9:19 p.m. to drive away, thinking he's heading back to his friend's apartment to sober up and warm up, that he had been sold. And how do you know that? You know that from a number of different sources. The first of which is the video surveillance. The video surveillance from Milford County and the video surveillance from the Select Mart. William Harlan walks into view at 8:39 p.m. that night. And he mills around the front of the Select Mart. There's no disturbance. There's no altercations. And there's no fights by anyone on that video surveillance. Nothing happened except for William Harlan milling around and walking around in front of that store. At 9:00 p.m., he decides to walk around to the east side off the view of the camera, puts his bag somewhere, comes back around. The defense is speculating that he was robbed and stabbed. There's no way that happened. Common sense and your experience will tell you that that just did not happen. William Harlan was there for 40 minutes. And nothing happened in that period of 40 minutes that he was there. When he walks around at 9:02 p.m., he continues to mill around. Walk, doing what he had been doing from 8:39 to 9:00 p.m. And then again, from 9:02 to 9:12, when Conway Malone pulls into the Select Parks to get gas. He continues to mill around outside in front of that store. It isn't until 9:16 that he goes into the Select Park. And you heard the testimony of Officer Boots. Nothing happened outside that Select Park. Not a disturbance, not a fight, not an altercation of any kind involving anybody outside the front of that store. And so he walks into the Select Mart to purchase some beer after getting money from Nathaniel Parker Jr. And you can see on the video him walking into the store, walking through past the front counter, back to the refrigerated coolers where he selects beers, pulls them out, walks back, goes to the front counter, and pays for them. Now, what did you see on that video that would even indicate to you that he was stabbed? There is nothing on that video that would show that he was stabbed. Nothing. Not one incident, not one fight, not one altercation. He buys that beer and he comes out of the store. And when he comes out of the store, you can again see them standing for a minute before he ultimately walks over. Jeffrey had opened the door. He gets in and he slides into the middle seat. And ask yourself, if William Harlan had actually been stabbed 5 times, 3 times in the chest and once on each arm, would he have been able to do all that in a span of 40 minutes? I submit to you the answer is a resounding no. He would not have been able to walk around the store, go and purchase beer, walk out of the store, get into the car, and slide over. And once in the car, have some conversation with the people inside the car. But there's more that shows the fact that William Harlan was not stabbed. Other than him carrying on his business, walking around as if nothing had happened. The video surveillance shows clearly, and you are free to watch the video surveillance as much as you. You're free to review all the evidence as much as you want during the course of the deliberations. But that video surveillance shows you when he turns around and walk out that, and the still photos show you that he had not been stabbed. There are no cuts in his coat where he had been stabbed. They're just not there. And the reason that they're not there is because he hadn't been stabbed. Those stab marks show up on his coat, and you can look at those photographs. And you can watch that video surveillance. There's William Harlan right there. Walking out of that store. You can examine that photo and you can clearly see he had not been stabbed. And you can compare that to the photographs or the coat itself. And those stab marks are not there. So the question then becomes, if he wasn't stabbed while he was at the select mark in those 40 minutes of time, when was he stabbed on February 24th? There's a 16-minute window of time between 9:19 p.m. and 9:35 p.m. That period of time is when William Harlan was stabbed. William Harlan slides into the car, gets into the middle seat. Jeffrey Lee has some small conversation with them. And where do they go from there? They go to the drug house on Jones Street, 1521 Jones Street. A couple blocks to the north of the east. Jeffrey goes in to get his methamphetamine. He's in there for a few minutes. He estimates about 5 minutes or so. The defendant's dad thought he was taking too long, so the defendant's dad comes and tells him to come on. Jeffrey gets back in the car. And what does Jeffrey notice when he gets back in the car? A change in the condition of William Harlan. No longer alert. Sitting upright with his head back. Not alert. Now, according to Jeffrey, that he passed out seems to be a reasonable conclusion. But he hadn't been passed out. He'd been stabbed. They leave the drug house on Jones Street and go directly back to the defendant's dad's apartment on 11th Street. They pull in and see the video. You see the defendant pull William Harlan out of the car, toss him to the ground on the bag of garbage. There's blood on the ground. That blood on the ground indicates that he was stabbed. He had been stabbed at that point in time. So what happened between 9:19 p.m. and 9:35 p.m.? That's when he was stabbed. That's when William Harlan was killed. That's what the evidence showed you. It doesn't show you anything that happened before that 9:19 p.m. time, other than William Harlan walking around, living the last few moments of his life. That's all that shows. So something happened in the backseat of that car. And think what you want of Conway, it's clear he didn't want to be there. It's clear he didn't want to testify. But what he did say was that there was a scuffle in the back of that car. Something happened in the back seat of that car to, one, change its condition for Jeffrey to take note of. Two, for Conway to testify that something happened to the point that the defendant's dad had to turn around and tell him to knock it off. And he didn't do it because they're at a drug house, he was so concerned about being at a drug house. Something happened to the point that caused him to turn around and tell him to knock it off. That's the point that William Harlan said in that deal. That scuffle that Conway Malone wants to minimize and not talk about and be evasive about, that's when he was stabbed. They weren't playing around in the back. That resulted in the defendant's dad turning around and telling him to knock it off. That's the point that William Harlan got stabbed. Now, the defendant doesn't want to admit to that or agree to that, but even in his own testimony, he had to acknowledge, and he did finally admit, that he had to have been stabbed when he was in the car. There's no other explanation. No other reasonable, common sense, logical explanation for when William Harlan got stabbed, except for when he was in that car at 9:19 p.m. and 9:35. There just isn't. And the defendant has to admit, and he did, reluctantly. But even his own admission says that he was stabbed inside that car. So where does that leave you with the evidence? If he was stabbed inside that car, again, when you read through your jury instructions, it's important to consider a couple things. These are things that we talked about during jury selection. Reason, common sense, experience, things that all matter, things that you use every day to make decisions, draw conclusions. These are things that you need to do and take back when you make these decisions about who did what and when it happened. So we talked about when it happened. So who did it? William Harlan was sitting in the middle seat. The defendant was seated to his left. We know that Conway was his right. We know that the defendant's dad was the front seat passenger. We know that Jeffrey Lee was the back rear passenger. We know that the defendant was the rear driver passenger. And we know that William was in the middle. The defendant was seated to William's left. Where was William stabbed? On the left side. We know that the defendant was in possession of that knife. He'd been in possession of that knife throughout most of the day, if not all of it. Early in the afternoon, when it was still light out, he was over at Jeffrey and Adam's place, showing Jeffrey the knife. You see him carrying the knife on the video. But whatever. Consider the fact that this defendant is found hiding in the bathroom with no light. Towel and the placemat in front of the shower is all wet. Someone that been using the shower. The tile up above the ceiling is a jar. Why is it a jar? Because that's where this knife was hidden. Wrapped in a t-shirt with blood on it. Hidden away to not be found. Why does someone hide something? Because they're guilty of something. It's not because they're trying to do something from their sister who from the steal. It's because you're trying to hide something that you don't want to have. And then when it's clear that officers are there trying to remove people, he remains in that bathroom, not saying a word. And then he's taken out of that bathroom. There's blood on that knife, but we know there's blood on that knife. The knife itself has a blade over around 10 inches. You look at this particular knife. When the jury instructions will say that by law, this is a dangerous weapon. There's blood on this knife. William Harlan's blood is on that t-shirt wrapper. He's wrapping that t-shirt up and it's hiding it. Keep it. So what about the blood? Where's the blood? That's why she didn't believe that there's blood all over the place. Blood in the car, blood on the seats, blood on the seat. But truly think about this for just a minute. Use your reason and common sense. What do you call it? William Harlan's clothes are soaked in blood. William Harlan's winter coat is a coat that it's on waterproof and it holds things in. Now, two of those wounds, wound A and wound B, to William Harlan's left chest. If you recall, Mark Smith in his testimony. If you recall, he's the paramedic, one of the paramedics that showed up on scene, and they cut up human clothes. They cut up their clothes and try to pull it apart to get injury quick and stay. He said that those wounds weren't right. He hadn't even noticed one of the arm. Those weren't actually. Remember the testimony of Dr. Thompson? What did Dr. Thompson say about it? Puncture the lung, sever the blood. How's that blood? Where's that blood going to go? It's filling up his chest. If William Harlan is seated up, which he is, that blood is going to stay inside. It's not till he was thrown onto the ground, pressured him a little bit, and some of the blood comes out of him. But that stab wound under his arm, when he stabbed, that blood is filling up his chest. There's not any blood still. Heard the testimony of both Sabrina from the DCI. She was talking about her experience, both as an expert in DNA and given her experience as a crime scene person. The squeegee effect. The knife being pulled out through multiple layers of clothing, it's going to clean itself off. And you also heard Officer Rios testify about that. And even in his experience as an officer, the rare times, very rare, where there's blood splay or cracks splatter from a knife. The reasonable explanation for where the blood is, there is blood in the car. Is that His coat was holding it in. It was filling up his chest cavity, but his coat was holding it in. And how do you know that? Again, I'm going to refer you to the testimony of Mark Smith. Remember what Mark said? He said that when they got there, the two wounds that he did see, they weren't actively moving. They get him put on the backboard. They transfer him to the ambulance. They continue to take him to the hospital. They get him to Mercy. They take him off. What happens to his arm when they get to Mercy? Falls off. Where's that blood go? That coat that had been containing that blood started streaming out of his left arm. That's where the blood was. And Mark Smith testified it just kind of left a blood trail. Pool of blood and a blood trail because his arm fell off as they were pushing him in. That's what reason and common sense will tell you about what happened on February 24th, 23. William Harlow was stabbed to death. Something that you should consider is the defendant's use of methamphetamine. And what the testimony of Joe Morel, the toxicologist, about the effects that methamphetamine has. Lack of motor control. It's a synthetic stimulant. This defendant said he'd been using that for days, multiple days, 3 days. That he had been using that and he would use that day as well. Kind of effects happen to people on that. And the testimony of Joe Moret or lack of judgment, increased stimulation, increased aggression. Things that you should consider about what happened on that particular night. And as you think about what happened on that particular night, this is when the jury instructions come into play. And what you should take the facts and you apply instructions that you do. The first one that I would direct attention to is instruction number 11. It says, in considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. And then jump down, the law makes no distinction between direct evidence and circumstantial evidence. Then flip over to instruction number 12. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. That's what I would ask you to do. In making the decision on when William Harlow was stabbed. And then again in making the decision who did it. The defendant was angry. You know that in the testimony. Pushed Jeffrey to the side, he grabs him, and he throws him to the ground. That tells you what his thought process is and what he thinks of him. It's not because that he was soiled or urinated on himself. It's because that's what he thought. Now this defendant denies that he did. he'll only admit that it happened in the car. So if you turn to instruction number 18, it sets forth what the state has to prove. It gives 4 elements, there are 4 things that the state has to prove. The first is that on or about the 24th day of February 2023, the defendant's we know that William Harlan was stabbed. And the evidence I would submit proves that it was the defendant, Nathaniel Parker III, that did. 2, that William Harlan died as a result of the stab. Well, we know that William Harlan died. And we know through the testimony of Dr. Thompson that the stabbing is what killed him. Most specifically, the stab 13 centimeters deep under his armpit that punctured his lung and cut his aorta. The defendant acted with malice aforethought. The defendant even admitted that whoever did it, according to him, would have acted with malice aforethought. And if you flip to the next page, the next few instructions kind of defines what malice is. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another, or in disregard of the rights of another out of actual hatred, or with an evil or unlawful purpose. It may be established by evidence of actual hatred, or by proof of deliberate or fixed intent to injure. It may be found in the acts and conduct of the defendant, and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another, which exists before the act is does not have to exist for any particular length of time. When you're wielding a knife, such as this one, and you stab somebody 5 times with it, 3 times in the chest, one stab wound is so deep, it's hard to kind of imagine how deep that is in your body until you look at it on somebody else's body, like Dr. Thompson showed you. How deep that cold steel is going into your body. And you do it repeatedly. That's malice. And the disdain and the disgust that he had for William when he took him out of the car and tossed him to the ground like garbage. That tells you what he thinks of William Harlan. There are further instructions a couple pages back. Instruction number 25 states that malice aforethought may be inferred from the defendant's use of a dangerous weapon. And then in jury instruction number 26, the dangerous weapon is. This knife is a dangerous weapon. And so the state submits that when the defendant stabbed William Harlan on February 24th, that he did so with malice aforethought. And the last element is that the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill in public. There isn't any specific amount of time that it takes to premeditate, be deliberate, and act willfully. No preset amount of time in these jury instructions. When you consider that question. But when you take a knife, a weapon like this, and you stab somebody in the chest multiple times, That's a specific intent to kill. You're intending to kill somebody. And when you do it repeatedly, you're doing it with premeditation. You're doing it willfully. And you're doing it deliberately. Why else you do it more than once? Because that's the reason that you're doing it. 5 stab wounds, 3 to the chest. 1 that severs artery and punctures lung. That's enough for you to conclude and find that this defendant committed murder in the first degree on February 24th. Now you can read through all these instructions when you get back to the book of information. And you can look through all of the evidence. But what you'll find is in instruction number 18, the state doesn't have to prove why it's the defendant wants you to think we have to prove his motive. But we don't. We don't have to prove why he did it. We just have to prove why that he did. And think about that actually. Think about that concept. And what you hear in the news. People get killed all the time, unfortunately. People leave behind it. They were just killed. Harmless murder in February. When the police show up and respond, they find this defendant hiding in the back. When they pull him out, the cops want to do the basic and everyone there. Answer simple questions about who he is. That night was cold, wet. When they pull it out of the single tile. Why is it there? Because the defendant knows. And he doesn't want to get caught. Why is he? Give him a little bit of that. Instead of hiding that up. Pretty simple. Give him a little token. He's at that one. Really looking more. Distract their attention on the map. And not on the murder weapon that I hid up in. Everything that happened on that night. William Harlan walking to the store, select one, going about his business, getting into that car. Thinking he was going to a friend's house. Not expecting him to be murderers. Conway Long didn't see the character much time. He was pretty kind of weird about it. Walking around, using the phone, coming in for work. Testifying or ready to testify. Then it was a whole lot about William Harlan. Pulling him out of the car and telling him to found that carnage. Maybe she could have. He was murdered by this. She held accountable for it. So you should care about what it's for. Even if this defendant doesn't. Even if Conway alone doesn't. should. He deserves justice. Make sure that discipline is how it comes. And that justice is served. The word of God. I'm asking that you do that as hold this defendant accountable for what he did and take responsibility. Hold him accountable for what he did and I will deal with the murder.
Mr. Los, argument on behalf of the defendant.
Yes, Your Honor, thank you. Please, the court.
Mr. Los.
Please. Ladies and gentlemen. Mr. Mulford, Mr. Parker, and myself, all for your time and attention. You have done a very good job in listening to what's been presented here. And I'm going to ask you to pay attention. One probably, right, probably the most important thing. Or not. It's this. What you the night could not have had any love. How do we know? For a long period of time, exciting in that. Now, Spade wants to talk about but there would be some blood. Not a drip, not a drop, not a single red blood cell of Mr. Hart on that. Nothing. If it's not good blood on this red picture. Oh, there's not now. It doesn't. There is no possible way that happens. What? Mr. Barker, tells you how it's happening. Because, and you can see this from the video, this color is open. He carried Mr. Harlan, his shirt got soaked. Now, how do we know that this is why? Well, because when he's talking to the officers, and you have that video, his shirt that he's wearing while he's talking to the officer has a big wet stain on it. Right there for you. Matches up. Get the stain on the wrench. How did the blood get on the knife? From the shirt. That has the blood from Mr. Hart. Very bad. Supposition. All the other maybes, all the stuff. State one. Fill in the blanks. They don't have the answer because it can't be divided. 30. They're there, you can look at it. Because of that. You see? Like, he's the only one who told me. That's pretty good. So, you see. And so when you consider up in the half, sit back. Now, also. Thoughts. Considering why he wanted you to move. Which is part of his anger. Because right away we have video that's different. We have him talking to the officer. You saw his wasn't angry, he wasn't fighting. Now, he was upset. Officer told him when they got there. Not listening, and he jerked out of it. Well, remember, I was less than 2 minutes and had a problem. And he had to spend time talking to Mr. Lee because he wasn't listening. Describe smaller rooms that you could understand in fire. In fact, a room that doesn't even have its toilet closed. Because it's broken. So where's open? He told me. He didn't hide his drugs. Because that's what Wesley asked. If they got they don't know. First. With the knife. With the knife. I'm considering the activists. And can't prove anything. He doesn't know, and I don't. If anything at all happened to this property. Say, what do you think? A determination. But I would also ask you to consider everything. A homeless man with his belongings disappeared. I don't know if that means anything. Because I wasn't there. And I can't. But it's possible. When Mr. Harlan with the remember, part of it is so all kinds of knives and stuff. The wound is saying I'll be described the wound. Really? That's not big. It's that's the part. Neary did testify that Mr. Harlan couldn't have standards. Well, then at 10 o'clock, and some of the other testimonies, the Harlans still alive and not. We don't know what we don't know. Hey, has that burden. That's the truth. It's not happening. That's not his job. It's done pretty fast. Back to that. How fast they settled on Mr. Barton. Thought I was taking way longer than that. They saw that. They found that it looked like. They believe that Mr. Parker throwing down Mr. Harlan. That's we can get it. So it states magic code. Campaign. Down. Bruce. Somebody's gonna take pretty significant. Some just. Done. So we had to decide that. I'm going to die. No reason.
That's right. We need to take a break. So, that's right. No. Just hold your thought, Mr. Lowe. Go ahead and we'll just go ahead and take a break and we'll use the restroom. So that's great. In the picture, that's Thank you. We do. I think it's, yeah, maybe it's one. You'll even had it written down, but the headset. And then it goes running up the road. I don't know why we're not getting a picture. I got it set like it's supposed to be. But oh. Yeah, well, I thought I did. Oh, no. Those watching by Zoom, I'm going to jump out of Zoom and jump back in and see if we can't get a camera to show what's actually happening in the courtroom. I don't know why I choose it. I'll see if I missed something at the beginning. There it is. I see it now. I think we're good now. Yeah, that's what we wanted before. I thought I had that clipped and obviously didn't. So. I don't know why. But came on earlier, I think, but then maybe my mistake. fine. Okay, for purpose. Needs you to go, it's just. Keep out my eye. Yep. Yep. I don't, I had, it showed it earlier. That's why I wasn't sure because I actually had this up earlier for a split second, it seemed, and then it went off and I didn't do anything to, so somehow the camera got shut up. I don't know how, but we're back on, so. That's why I thought something else was wrong because I had seen this view. I don't know. So. Whenever she tells us she's ready, we'll wrap it up. I don't know a name, Okay. So while we're waiting a second, James, will you plan on having a computer here? So if they want to watch a video? Cause I don't, yeah, cause I don't know what else to do. We don't have anything we can send in to them, I don't think.
Yeah. I can just-
I'll mention something about that so that if they just need to request and then we'll get it set up so they can do whatever it is they want to watch, cause
Judge, are we ready?
yeah, we are ready, aren't we? Yeah, let's go ahead and have everybody can come back in. Um. And the Plymouth County criminal case is a 2-day max. I think they only have like 4 witnesses. I don't know if they're gonna have a defense on Bob Rock, Darren. I think Darren's trying that. I think so. I'm not sure. Yeah, I can't remember what he told us. Jason. So that's the easiest of the two, but the civil one is gonna be a. Sorry about that, but it will be. I just know. It's the way the lawyers have not gotten along so far. Mhm. Don't worry. All right, everyone may be seated. Mr. Lewis.
Thank you. Steve, for doing that. I apologize. So we have six more. So. Get to decide. Your job. Well, let's look at that. Let's see what we know over there. If we know that the reason for picking up Mr. Hartman is that he was known to be transient very, very cold. And he was out there. So, good motive to start with. That's what we're talking about. That's the reason. And then, these new people taking Mr. Hartman, you know, taking inside. And then he's talking with the detective. Sweet. So stressed and worried. That they're gonna figure out these staff that. Someone. Why? I think that's the first thing you should consider. He carried him into his dad's house. He assumed if he had killed him, he would want to go somewhere else. Get rid of him, so to speak. But certainly once figured out that his dad was calling him for help, I gotta get out of here. No, none of that. None of that. Remember, that was said. He wasn't upset. He wasn't upset. Wasn't agitated. I think those are good clues as to what frame of mind. For parents, you thought. Mr. Numbers. Have fun. Obviously, you can smell that. And then you notice it. And so. Where someone. The difference in Mr. Lee's story. Mr. Lee, telling him out of the way. You want that? Please do. Walks over there, calling him. Push out of the way, slides in there. Get Mr. Harper out of there. And hold him in. It's got this. That's. Now, did he hate him so much that that's where he left him? Then fix him. I don't admit it. And he does carry him into the apartment. Now, what did he also have? Okay. That's where he is. You know, we turn us. And there is some on time. We don't know. So, you know. Maybe it came from the teacher. Yeah. Don't know. Again, that's not history. Wow. It's got. You know, nothing on that. You can run. You do know. You help pick him up. You do know. Both that shirt and the shirt he's wearing on the video all have the wet buttons. You know those. The other man on the car. Right. Really good. He even asked me if he did. I'm told no. It's so bad. Please. Not true. Not expected. Not to ask you to connect it. Once you die, I'll be in. I'm gonna say that happened in the car. And Mr. Parker was out of his mind. Drug-induced pain. That he decided he's gonna stab Mr. Harley. Why? In that little car. That straight in that little
looking at.
Mr. Loomis, the state's rebuttal.
Motivation. And it had not- Trust about what he wanted to say. Trust about where it would see it, watch it, watch all of the videos. Decide what to tell you, that they're going to stand 8 months. That's motivation. Motivation is one thing that you know will take away from them as a pilot. You decide about concealing. Hoping. That no one's gonna see them. Motivation is sitting down and telling Detective West, I blacked out. And coming over here and sitting down and telling you all sorts of details about what happened that night. That's motivation. The state's not asking you to make assumptions. The state's not asking you to fill in all these blanks of unanswered questions. The questions have been answered. When did it happen? And who did it? You're entitled to use your reason, common sense, observation, everything that you do in your daily life to draw conclusions. Mr. Most doesn't want you to do that. But it's clear in those instructions that you can, and you should. Because common sense leads you to the conclusion that this defendant on the night of February on court. Justice demands that you hold him accountable. The evidence points to one person. So think about motivation in that way. Who really has motivation? What is that night? So what is the time? So what do you do?
Thanks, counsel. Okay, so you now have the case completely ready for your consideration as jurors. I need to identify our 2 alternates and excuse them. And as I told you, we had a process that we designed at the very beginning, and so Mr. Niehaus and Mr. Byers are their 2 alternates. So you get a pass today. You don't get to deliberate, but that's how we do it, because we obviously didn't know whether we'd need you or not. So that's how the process is. And so in a moment, when I excuse the jury, we'll just have you go ahead and turn your things in. And I thank you for your service personally and on behalf of the court system. Just a couple other sort of housekeeping things. I would ask for the time being that the exhibits that are enclosed in any plastic, as those clothing items are, and the weapons that are in boxes that are sealed, that you examine them in that state, that you not open them up and handle them and those kinds of things. But feel free to look at them as they're sealed and closed, because we will need them back when you're done with your deliberations. Additionally, in the event that you decide you want to watch any of the videos, that's certainly fine. Just let us know with a note. then we'll set things up here in the courtroom, bring you back in so you can watch them in here. It's just easier for us to do that on the bigger screen, and we can roll the screen over so it's closer to you and make it easier to watch. But I think at the time being, we'd have to send a computer back with you, and we'll just do it in a way that we can control how that all happens. You can probably surmise why we would do that. Just wanted you to know that ahead of time. Otherwise, I'm ready to swear in I'm going to treat both of you as clerks in this particular case, if you don't mind. And if you'll come around, we'll gather the exhibits, make sure they're all ready to go, and then send them back in a minute with the assistance of my court reporter. And so, Natasha and Jill, I'll have you raise your right hand. Do you solemnly swear that you will keep this jury together in the jury room except as directed by the court, and that you will not allow any person to speak to or communicate with them unless otherwise ordered by the court, and you will also not speak to or communicate with them yourself except to ask about whether or not they've agreed upon a verdict or as otherwise directed by the court, and that you will not communicate to any person outside of their deliberations the state of their deliberations or the verdict that they've agreed upon until after that verdict has been declared here in open court. And that's the exhibits that will be taken by you in a moment or delivered to you will be delivered to the jury and not be left unattended or tampered with until returned into open court. Please answer, I will. Okay, thank you. So folks, take with you the items we've given you except for the two alternates, and you can give those to us or leave them right on the corner perhaps of the next to the witness box as you leave. And I don't think there's any other message we need for the alternates, is there? No, you guys are done with your service, and I thank you very much for your willingness to do that. And so everyone, please rise. The jury is excused to begin their deliberations. Yeah, okay, good. Thank you. Yeah, we'll have one other one, I think. The other one was Mr. Byers and Mr. Niehaus. You may be seated. We'll just make sure. Did you hear the name, Cheryl? So that Byers and Niehaus, and I don't know which one. That says on the top. So anyone that's on YouTube, we will try to fire this back up when we know we have a verdict, but I will go ahead and shut it down now.